When Josh Hawley speaks, he rarely wastes words. He frames questions like a sculptor, removing everything non-essential until what's left is the core truth he wants placed on the record. Today, that truth is the question every lawyer and litigant cares about. How will Emil Bove read the law when what the statute, or the Constitution, doesn't say plainly? That's what judicial philosophy is, the set of invisible rules a judge uses when the text runs out of answers.
Mr. Bove, nice to see you. I enjoyed our conversation the other day. Congratulations on your nomination. If I could, let's turn the focus of the discussion back to the law. I want to talk to you for just a second about your approach to the interpretation of statutes, which is something that we discussed when you and I had a chance to speak earlier. When you encounter, as you will constantly on the Third Circuit, when you encounter an ambiguous statute, what's your general approach? What do you consult? What's your approach to interpreting the text? Give us a sense of how you'll tackle this. What will be a daily occurrence should you be confirmed?
So in the face of an ambiguity, Senator, I would consult the context of the operative phrase, consider the statutory structure, look at usages of similar terms by the operative legislature at the time in question, because I think that matters, as I said earlier, with respect to enforcing bicameralism and presentment, and try to garner as much as can be from those sources, those textual indications. In the event that I think that those textual considerations don't resolve the matter, philosophically, I would be inclined to exercise restraint and not insert myself or a panel of the Third Circuit, if I was confirmed, into a position of declaring what the meaning of an ambiguity is, as opposed to deferring back to the legislature on that topic.
You just used the word text or textualist about 3 or 4 times. Do you consider yourself a textualist? Is that a fair assessment?
Yes, Senator.
Let's just think about a controversy that exists among those who call themselves textualists. Some textualists say that the statute ought to be interpreted, an ambiguous phrase ought to be interpreted according to the public understanding at the time that the statute was enacted. Other textualists, self-identified textualists, say that a text meaning sometimes only becomes clear over time. So there needs to be an elapse of time. You can consider what's happened in a space of time rightly to interpret an ambiguous phrase. Both camps call themselves textualists. Where do you fit?
In the first one, Senator, I think that an interpretive methodology that allows the meaning of a statute to shift over time, potentially over the course of interpretations by different judges under different circumstances, or at the whims of policy or political considerations, can be very problematic. If I were confirmed, part of my philosophy would be to do this job pursuant to the limited powers in Article 3 in a way that enhances the democratic features of the political branches. And by that, I mean focusing on the text, what it meant at the time it was put on the books, and deferring to those political branches on the other matters.
Okay, good. So I hear you to say that you reject the idea that an act's meaning can only become clear over a number of years. You think it ought to be interpreted as understood at the time it was enacted by the public, meaning at that time. Have I got that right?
Yes.
Good. Let's talk about substantive due process for just a moment. What's your understanding of that doctrine?
I think there's a basic test set forth in Supreme Court precedent that I would apply faithfully if I'm fortunate enough to be confirmed, that seeks to identify certain fundamental rights as a matter of substantive due process. That precedent, the precedent for that test, as I understand it, basically requires consideration of whether the right at issue is implicit in the concept of ordered liberty and also consistent with deep history and traditions of the Republic. There's a lot of academic writing about the merits of that test that I think for judges, particularly me, if I'm confirmed, is sort of beside the point. Because on the Third Circuit, I'd be bound by Supreme Court precedent, like the Glucksberg case, to apply that test in the context of arguments presented to me by the parties.
What is the leading Supreme Court precedent on substantive due process, to your knowledge?
I think the There are several cases that lay out and address the test that I just described in the context of discussing different fundamental rights. Dobbs is one of them. I mentioned the Glucksberg case, which is an older formulation of that test.
Yeah, in fact, the Supreme Court has used different tests over time. The substantive due process has two branches. No, it has the incorporation branch, and then it has the fundamental rights branch. You've been describing the fundamental rights branch. The court has used different tests over the years, frankly, to describe what counts as a fundamental right. Those tests are quite divergent, if we're being honest. But this court seems to have settled on one recently, and I think you just put your finger on the decision that most recently draws these themes together, these strands together. That's the Dobbs decision. Do you regard the Dobbs decision as settled law?
Yes.
As controlling law?
That is what I mean, is that it's a binding precedent of the Supreme Court that I would be required to apply faithfully if I'm confirmed.
And so you will apply the Dobbs decision not only in the context of life and abortion, which was the immediate context, but also for its instruction on the meaning of fundamental liberties under the substantive due process head. Is that correct? Is that fair to say?
I think it's fair to say that a judge endeavoring to be bound by the rule of law, which is certainly what I would be trying to do, applies all relevant Supreme Court precedents in a faithful way. And that would be my mission for life if I am confirmed.
But sorry, I want to be clear on this, just on this last point. This is important because there's lots of Supreme Court precedents that conflict with one another over the years. You will apply the current and controlling precedent to the matter at hand. Is that fair to say?
Yes, without hesitation.
Which in this case you recognize to be the Dobbs case. Is that fair to say?
Yes, I think Dobbs is a recent formulation of the substantive due process test that we're talking about.
That would bind you?
Of course.
Before I call on Senator Booker, Senator Moody has agreed to chair the rest of this hearing.
Hawley begins simply but surgically. When you hit an ambiguous statute, what do? It's an invitation to recite methodology, context, structure, usage, and Bove gives that recital. But then Hawley presses him to name the tribe. Do you consider yourself a textualist? That's a small question that contains a very large world. Saying yes doesn't settle anything, because textualists disagree with one another about what text means and whether meaning can drift. The hearing transcript makes clear that Hawley is trying to force a choice between two competing textualist visions, the snapshot view and the living history view, and Bove chooses the snapshot. He says the meaning should be judged by what it meant at enactment, the public understanding at that time, not by what later practice or judicial gloss might make it mean. That answer ties him to a fixed meaning approach to statutes and makes predictable how he'll approach legal change, incrementally through legislatures rather than through judges. That categorical commitment is more than an abstract label. It's a roadmap for concrete results. If a judge believes the text's meaning is frozen at enactment, then ambiguous protections, whether in health law, administrative statutes, or civil rights statutes, will be read against modern expectations rather than adapted to them. In plain English, if the law didn't foresee a modern problem, a fixed-meaning textualist will generally insist the solution be political, go to the legislature, rather than judicial. That matters to real people and real controversies because it changes the default path of legal change from courts to elected officials. Hawley then pivots from statutory interpretation to constitutional doctrine, and the air in the room changes. Substantive due process is the doctrine that has produced some of the most intense fights in constitutional law because it sits at the intersection of history, liberty, and judges' willingness to recognize rights the text doesn't explicitly list. Bove answers that he'd follow Supreme Court precedent, a judge's professional baseline, and he articulates the core elements, whether a claimed right is implicit in ordered liberty, and whether it is consistent with the nation's deep history and traditions. That language is the language of Glucksberg, the case that set the modern deep history and tradition test for fundamental rights. Saying you will apply those tests faithfully is, pragmatically, saying you will be constrained by what the court has already labeled fundamental and cautious about expanding that category. Then Hawley names the anchor, Dobbs. He presses whether Dobbs is settled law and whether its approach applies beyond abortion, whether its framing of substantive due process will be the lens through which future claims of fundamental liberty are judged. Bove answers yes. He asserts he would apply controlling precedent like Dobbs faithfully. That answer does two things at once. It signals fidelity to the rule of law, and it telegraphs what a litigant should expect, a court that treats the Glucksberg-Dobbs-style tight historical approach as the governing frame. In practice, that tends to make it harder for claimants to succeed on novel or evolving claims of liberty, because the inquiry looks for historical roots rather than contemporary understandings. Put another way, Bove's testimony maps a coherent judicial identity. He's a fixed-meaning textualist for statutes and a cautious, history-rooted applier of substantive due process for constitutional claims. That combination is consistent, philosophically. If you don't allow meaning to drift in statutes, and you insist that constitutional rights must show deep historical pedigree, then much social policy becomes the province of legislatures and not judges. That's not merely academic. It determines whether courts will expand protections for privacy, reproductive autonomy, or other emergent claims, or instead leave these decisions to the political branches. But there's a practical caveat in the answers. Fidelity to precedent doesn't erase judgment calls. Judges often decide how tightly to apply a historical test, how narrowly to define the right they're examining, and how to weigh conflicting precedents. Saying "I'll follow Dobbs" or "I'll follow Glucksberg" narrows the horizon, but it doesn't eliminate discretion about how one describes the right at stake, how one defines the relevant historical practices, or which historical materials one finds persuasive. Those are the places where future panels, precedents, and real-world facts will put any nominee's philosophy to the test. So what should viewers take away? First, Hawley's line of questioning was designed to extract commitments that matter, and Bove gave them. Second, those commitments point toward deference to the political branches and a historical-laden approach to constitutional rights. Third, being textualist or bound by precedent is not a single policy, it's a set of choices that produce predictable outcomes in statutory and constitutional law. Finally, the answers Bove gave are testable. They will show up in the way he writes opinions if he's confirmed. That's why these exchanges matter. They're not theater. They're an early draft of what a judge's jurisprudence might look like years from now. Tell me what you noticed. Do you read Bove's answers as clarity or as careful containment? Do you think Hawley got the commitments he wanted, or did the nominee leave wiggle room? Drop your take below, and if you want, I'll break this down into a short explainer on textualism versus living constitutionalism with historical examples and likely case law outcomes. If you found this useful, like, subscribe, and share. And tell me in the comments which legal concept I should explain next: textualism, Chevron deference, originalism, stare decisis, or the Glucksberg test. I'll make a focused explainer that uses real hearing clips and examples so people can see how these doctrines play out in court.